next argument we'll hear today is in case number 28-965, State of Ohio versus Darnell Roper. And once again, the state has waived our argument in this case, so Attorney Gilly, you will have 15 minutes to present your argument. As you know, the arguments are recorded. Keep your voice up, and we've read the briefs and are ready to proceed when you are.
Okay. Thank you, Your Honor. May it please the court, Attorney Angie Gilly on behalf of the appellant Darnell Roper. The issue presented today is whether or not the trial court abused its discretion in denying Mr. Roper's motion to vacate his guilty plea. And the answer to that question is yes. What we're asking the court to do today is to correct what we refer to as a manifest injustice. There's a complex procedural history here, which I'm assuming Your Honors have reviewed and understand. I'm also dealing with two attorney Whitneys. I realize it's a little bit informal, but if I'm referring to them, would it offend the court if I refer to them as Larry and Tyler instead of the whole thing?
Probably would be.
I thought it would be simpler.
Probably.
Okay, thank you. In Mr. Roper's case, a review of the trial court's decision, Judge Bro actually did find that there was, in fact, a manifest injustice in this matter. She felt as though what Judge Stormer and, well, she didn't include Judge Davis, but subsequently Judge Davis did in fact meet that standard under Criminal Rule 32. What she found was that the defendant failed to meet the burden of proof as it relates to whether or not he relied on that manifest injustice when entering his plea.
To enter the plea.
Correct. Correct. So we obviously agree with the trial court that there was an injustice. Very clearly, Mr. Roper was advised of a misstatement of the law, not only by his attorney, by the prosecutor, as well as by more than one judge, if you review all the transcripts. So, as it relates, our primary focus is that we feel that the court really erred by not reviewing any of the information in the hearings before Judge Davis. Tyler did object at the hearing he did object to her, or I'm sorry, there was an objection made to Tyler trying to introduce evidence as it relates to the hearings before Judge Davis. She sustained the objection and wouldn't allow it in. We feel that this is an error, and the main reason is because it's absolutely necessary to look at the entire procedural history of this case in order to get a clearer understanding of what the appellant's thought process was when he was doing this.
Refresh my recollection, counsel. When the case went back before Judge Davis,
Yes.
it was for what purpose?
It was for resentencing.
Thank you.
So, and I think that that's what makes it so imperative, because as the court is aware under Criminal Rule 32, if you haven't been sentenced, you can vacate your plea without really much of an issue at all. It's post-sentencing when it becomes an issue. So when Mr. Roper was brought back, he had no longer been sentenced. And he saw Judge Davis. Not only did Judge Davis discuss some of the plea negotiations that took place, she very clearly stated on the record that she felt that this was part and parcel of the defendant's plea agreement, that he was going to be released in 4 years. In addition to that, there was conversation between the court and Attorney Larry Whitney as it relates to this plea agreement too. Judge Bro decided not to review any of that, and we feel that that was in fact abuse of discretion. Because what she found is that, backing up a little, because Mr. Roper clearly could have vacated his plea back then when he came back for resentencing with Judge Davis if he wasn't under the exact same impression that he could petition for judicial release in 4 years. It's not an issue of whether he was promised it. There's no question it wasn't agreed to. However, it is pretty clear that he was told that he could petition in 4 years. He in fact tried. He was denied by Judge McKinney, and that's when he filed to vacate his plea, was subsequent to that. Unfortunately, he's had 4 different judges at the trial level during the course of his case, which makes it a little more convoluted as well. But the basis of Judge Bro's finding was really that he didn't show reliance, in part because there was an argument on the record as to when the appropriate time for judicial release was. And I actually believe that the court erred in their review of facts in that instance, because the only disagreement as to the time frame during the Judge Stormer proceedings was on pages 20 and 21, where Judge Stormer said that she thought it was 5 years. Larry Whitney said he thought it was 4. Prosecutor said 4. All three of them agreed that it was a 4-year judicial release filing time on the record. What they were arguing about was whether or not the state would agree, which clearly they've said they wouldn't agree to it. That's not the issue though. So in that instance, I believe the trial court erred on the facts. And furthermore, she said that his statement that he probably wouldn't get it was indicative that he didn't rely on that when he was pleading, recognizing that interpretation of what people say is kind of within the discretion of the trial court. As somebody who has represented hundreds of criminal defendants over the years, people saying things out of frustration, people saying things when they're confused and upset because of arguments that are taking place on the bench is more of a flippant response. He didn't say, well, forget it, I'm not going to file. To me, it sounds more of a despondent, well, I probably won't get it. But he clearly understood that he could try.
Counsel, my understanding is your argument is that the defendant, part of his plea bargain was that he would be eligible for judicial release, not that he would necessarily get it.
Correct.
The trial court in her entry talks about the fact that defendant thought he was going to be judicially released and talks about actual judicial release as part of the sentence. Was there any confusion as to whether it was a plea bargain that included, or a plea agreement that included the time for filing? Because I know that gets confusing in and of itself, because I know there's discussion as to whether it's 4 or 5 years, or that he would actually get judicial release. What was the actual motion to vacate, for instance?
In the motion to vacate, Attorney Tyler Whitney said that it was the promise of being able to file in 4 years. There is an affidavit submitted by Mr. Roper, and Mr. Roper does put in that affidavit, that's the only place that I saw that he thought that he was being promised 4 years, but he also said that he thought he was being promised that he could file in 4 years. So it's kind of, he says both in his affidavit, but other than that, there's nothing. I mean, I think Judge Stormer made it very clear that it wasn't a promise to be released. And this hearing in particular, in front of Judge Breaux, all of the testimony was promise to file in 4 years, not promise of release. I believe the trial court kind of went astray in that analysis as well, because they were looking at it from a more stringent perspective. And he's not under the impression that he would have gotten out in 4 years, just that he was going to be allowed to file for it.
Well, and that's, at the sentencing hearing, that's why that could be a reason why he said, I probably won't get it anyway.
That's correct. He understood that the state was opposing it. They made that very clear at every
He
hearing.
had the option to file.
Correct. All he was bargaining for was the option to file, and that was the basis of the motion. And I guess to back it up, in the motion that was filed by Attorney Whitney to vacate the plea, he also brought up that this had been discussed with Judge Davis as well. So the court was already on notice that the hearings in front of Judge Davis were at issue. So why she would not hear any of that evidence or testimony, I can't answer, and that's what we feel was incorrect.
So would you agree with me that if he had filed and he was turned down for reasons other than ineligibility, he wouldn't be here?
Absolutely. Absolutely. And I also agree that if this court were to allow him or reverse the decision and allow a vacating of his plea, that doesn't mean he's going to end up in a better position than he is now. And Mr. Roper understands that as well. We've discussed it in detail, as I know Mr. Whitney has with him as well. And the only other thing that I would like to point out is I also found it odd that the trial court said that there was no evidence in the record of the appellant's intent, but Mr. Whitney testified. Once again, understanding that the trial court judge's credibility, the testimony of a well-established, prominent attorney, I feel to be extremely compelling. Mr. Whitney made it very clear that he felt that Mr. Roper understood and was compelled by this agreement that he had discussed in chambers. Even though the primary discussions took place in chambers, he testified as to what took place in chambers. In addition to, there was also some discussion, primarily with Judge Davis, on the record as to what those intentions were at the time that the plea was negotiated. If there are no other questions, then I will rest on my brief.
All right, thank you very much for your presentation today. The court will take take this matter under advisement as well, issue a decision in due course. The clerk of courts will mail the decision to counsel on the day it's released. You can also keep an eye on the Supreme Court's website as the opinions are posted there as well. Thanks again for your argument.
Thank you.